Hi, good afternoon. My name is Michael Peabody. I am an attorney here at the Tarzana office of Bradford and Barthel, where I've now been for 9 years. I actually started out here in 2001, was here for about 2 years, and then left for a couple of years to do some other stuff, and I'm now back. And today we're going to be talking about some recent case law that's come into place and some WCAB decisions. And one thing I do want to caution is that a lot of the cases we'll be discussing today are not citable authority, but they do demonstrate the direction that the WCAB and the appellate courts are taking on some cases. So they're worth paying attention to. Case law is all about the stories of what happens in a case. It's what goes on when a person files a workers' compensation claim and gets an attorney and a decision is rendered at the board level that one of the parties isn't happy with, so they appeal that decision on up. Please keep in mind again that the purpose of this presentation is to describe legal trends, but does not provide legal advice pertaining to your particular cases. Some of the cases that we'll be talking about again are unpublished and cannot be relied upon in legal proceedings. If you have questions related to the facts of your case, be sure to consult with legal counsel, or you can always call me and I'd be happy to discuss it with you. My contact information will be in the slides as well. So beginning, we're going to talk about the case of Peter Sylves. He was a police officer in the county of Riverside. He's actually working for the County Riverside Sheriff's Department, and he was there from 1998 until 2010. After that, he began working for the Payuma Band of Luiseño Indians from 2010 to 2014. And that is a group that is actually under federal jurisdiction and not under the jurisdiction of the Workers' Compensation Appeals Board. So if he were to be injured while working for the Payuma Band of Luiseño Indians, he would be unable to appeal that decision to the Workers' Compensation Appeals Board or have it heard at the courts. In 2013, a doctor found injury to his left shoulder, bilateral knees, GERD, and sleep. So it's the typical range of injuries that we often see. However, the WCAB lacks jurisdiction over the tribe. In July of 2014, he filed an application against Riverside County, again for those same body parts, the hypertension, GERD, left shoulder, low back, and both knees. Now you notice he hadn't worked there for 4 years. In June of 2015, the case went to trial, and the trial judge actually wrote a ruling that discussed the statute of limitations, and the judge said that pursuant to Labor Code Section 5500.5, applicant's continuous trauma is limited to the last year of industrial exposure, even if it is with the Payuma Tribal Police. If you're looking at this from a perspective of a statute of limitations, this is potentially a problem because 5500.5 typically addresses issues having to do with contribution between defendants and which defendant is liable for the last year of injurious exposure. Anyway, both of the parties appealed the decision, and Riverside County said, well, it doesn't matter what the statute of limitations is, it's not us, it's Payuma. And Sylves argued that 5500 had nothing to do with the statute of limitations, and that since the WCAB doesn't have jurisdiction, that case needed to go back to Riverside County and be addressed there. Sort of a situation where you've got a period of time for which the applicant does not have coverage. The District Court of Appeals found that the county didn't give the DCA any reason to find that the application was untimely. He'd actually filed it within a year of when the doctor told him he had that condition. So the regular statute of limitations didn't apply according to the District Court. And even if his work was the same for the tribe as it had been for Riverside County, and that was what the facts were showing in this case, it was the same type of work that would have exposed him over time, and therefore, even in the words of the code section 5500.5a, he would still have been exposed to the hazards of the occupational disease or cumulative trauma. So, using a SIGA type of approach, the court applied language from the code that states, in the event that none of the employers during the last year of occupational disease or cumulative injury are insured for workers' compensation coverage or an approved alternative thereof, liability shall be imposed on the last viable carrier. So even if the applicant is working for a company for a number of years that has no workers' compensation coverage, it can still attach to the last viable carrier, which would have been the carrier for Riverside County, and therefore Riverside County is liable for the injury. Since the WCAB didn't have coverage of Piuma, it was uninsured for purposes of the statute, according to the district court, and liability again passes back to Riverside County, which was insured. So a couple of things we can draw from this. First, the statute of limitations begins to run when the doctor tells an applicant that he sustained an industrial injury. 5500.5 doesn't speak to that statute of limitations issue. And if the applicant has the same kind of job over time, even if the subsequent employer is uninsured, it goes back to the previous employer. So they go back to the last pot of money, and it was Riverside County. So that's the way that decision came down. So what happens when you have body parts that are not addressed in an AOE-COE decision? This is a case that I think a lot of us can relate to. It is the Enrique Iniguez versus WCAB Blue Rose Concrete Contractors, which is an unpublished Second District Court of Appeals case. This is a case where I think a lot of times we would have thought that we would have been the winners in the case as defendants, simply because the judge did not mention certain body parts in their initial finding of AOE-COE, or that it arose out of the employment or was caused by employment. And the facts in this case are that in 2010, the applicant filed a claim for the head, neck, back, shoulders, and legs. And the case went to AOE-COE trial. The case was obviously denied. And at that time, he claimed foot, shoulder, and right arm, but didn't mention the neck or the back at the trial. And so the judge found that the injury was compensable to the right shoulder and left knee, and did not mention any of the other claimed body parts. So you can see that the claim initially was a foot, shoulder, and arm, and he found shoulder and knee. I guess the knee and the foot would be the same according to the way it had been pled. But anyway, he didn't mention the other body parts. And neither party appealed that decision. So partly compensable, other stuff nothing mentioned about. Later on, the applicant filed again for AOE-COE findings on the other body parts. And the judge went back to his 2012 decision and said that since he didn't mention the other body parts, there was an implicit finding that they were not compensable. But the original ruling did not say that the only body parts the applicant injured had been the right shoulder and the left knee. And that case went up on appeal. On appeal, the WCAB panel agreed with the judge that the other body parts were implicitly non-compensable because they hadn't been mentioned. But one commissioner dissented from that decision and said that just because the trial judge did not mention the other body parts, it did not mean that those other body parts were dismissed, per se. It simply meant that they were not mentioned. That case went up to the Second District Court of Appeals, which found that the claimed body parts had not been the issue in 2012, and that the unmentioned body parts were left for future hearings. In other words, the body parts that had not been addressed at the time of trial still were left out there, and the applicant could reapproach that later on with a new AOE-COE trial or assert those. So the judge's decision, in other words, had not been complete. The court said it is one thing to conclude that there were industrial injuries to the right shoulder and left knee, and it is quite another decision that these were the only injuries. So I found this case to be kind of troubling because you have a judge who finds certain body parts compensable and simply didn't mention the other body parts, and so you'd think that they'd be dismissed or not found compensable, but you really need for the judge to issue a determination as to the other body parts and whether or not they are injured. That creates a situation that's kind of uncomfortable, whereas a defendant, in order to escape this type of situation, you'd actually have to volunteer to the court that the applicant was claiming additional body parts that hadn't been addressed at the pretrial conference statement or at the time of trial, and make the judge come up with a ruling about those other body parts. I find that to be a very troubling scenario to try to play out. And it would seem like it would be incumbent on the applicant's attorney to make sure that all the claimed body parts were being addressed at the time of the initial trial. If they knew the body part had been injured, they should address it right away and not wait until later. Just because the parties and the judge are silent on certain claimed body parts during an AOE COE hearing doesn't mean they're off the table. And I find this to be an uncomfortable result. Hopefully a stronger case goes up and they can actually come out in the opposite direction on this one, because that decision, I have trouble with it because it simply doesn't fall in line with the way that workers' compensation is typically practiced. But at this point, the main thing to do is, if the applicant's on the stand and they're only addressing certain body parts, get them to say those are the only body parts that they're claiming. You know, when they're testifying, say, look, so you're telling, your testimony today is that you only injured your shoulder and your knee, is that correct? And they'll say yes. And then you're okay on this. Other than that, you'd have to name every body part that they may have possibly addressed in the past. Next case is Daniel Ramirez versus WCAB. This is one of the cases in line with Dubon where applicants' attorneys are continuing to try to get out from under the utilization review and independent medical review program and process. As a typical workers' compensation injury to the leg and ankle, state fund authorized more than 24 acupuncture sessions, and the doctor, of course, wanted even more than that. State fund submitted the request to utilization review, and UR non-certified it. He then went to independent medical review, and independent medical review agreed with utilization review. This happens often. IMR often will certify the results of utilization review. Anyway, Mr. Ramirez's attorney complained that the rules that keep the name of the IMR reviewer confidential prevented him from completing necessary discovery and were violating his due process rights. He argued that the utilization review decision had not been based on the medical treatment and utilization schedule. So he attacked the IMR decision from a number of directions. And the Third District Court of Appeals concluded that the process was, actually, I put the wrong word, it should say the process was constitutional and that Ramirez should address any complaints through the IMR process. And he appealed to the third DCA again for reconsideration of the same decision, and the court denied that request, so the decision stands. Utilization and IMR remain the law of the land. There is no due process violation when it comes to knowing who the doctors are making the determination at IMR. This is a fun case. The Aaron Carrillo versus WCAB case was writ denied. I include this case because it's so obvious that the case was non-compensable, but sometimes when you see facts like this float to the surface, it makes you question all your assumptions about how the law works, and you have to start looking stuff up to make sure you don't have it wrong, because the arguments being raised by the applicant are so out there that it wouldn't seem possible that somebody would raise them, and so you want to make sure that you're not hearing it wrong. But here's what happened in this case. It goes back to April of 2011. Carrillo was working as a bus person for a restaurant, and business was slow on April 18, so his boss sent him home early. And his girlfriend was working there at the time, so he decided that he would wait around for her. So he changed into his street clothes and decided to spend some time drinking at the restaurant. And he became stinking drunk and was so noisy and obnoxious that his boss actually asked him to leave. So Mr. Carrillo got into his car, drove away, and had an accident. Of course, being California and being a workers' compensation state, Mr. Carrillo filed a claim. And he lost the claim at the trial level, and he appealed it and lost. And he actually filed to the District Court of Appeals, and they denied his writ. And then he appealed to the California Supreme Court, which also denied certiorari. So all the way up, this guy kept fighting the case, fighting the case, fighting the case. Apparently he had some theory as to how his drinking after hours at work and involvement in an accident, likely due to his drinking, was industrial in nature. That got appealed all the way up, and he lost every time. So maybe this court case can restore your faith in the system because sometimes it works. That's a non-compensable case. Okay, this is a case having to do with what happens when you stipulate to an injury that happened at work and you stipulate to a permanent disability level, and later on find out that the applicant's level of disability is not accurate and that you overpaid on the case. In the city of Santa Maria versus WCAB, this is a case that was heard up in San Luis Obispo, the Sean Gowing case. The parties stipulated that a police officer sustained permanent disability for the back and knee. Then the defendant obtained surveillance showing that the applicant was engaged in activities that were not consistent with that stipulation. So the guy was off doing all kinds of things that he would not have been able to do with a back and knee injury. Obviously, after the case settled, he probably thought he had more freedom to act without having to be surveilled and having to worry about people claiming that he was being less than honest with the doctors and with the court. Even the AME looked at the surveillance and said, yeah, it doesn't appear that the applicant has any back injury or any back disability. But there's a big however in this case. Case went to trial, and the judge found that there was no reason for a reduction in permanent disability unless there was, one, some reason to show that the applicant's condition had changed from the time the disability awards were issued, or two, there was a reason Subrosa videos could not have been obtained and reviewed before the awards were issued. In other words, new and further disability is disability that arises after the stipulation, and a reduction in that disability would be something that arose after the stipulation. If you can't show that the condition had changed or that you couldn't obtain the video ahead of time, then you're kind of stuck with what you stipulated to. That case went up to the WCAB, and the board agreed with the trial judge that there was no demonstrated change in the applicant's condition, and the Court of Appeals denied the writ. So the practice pointer on this is that a reduction in permanent disability means that the reduction would have occurred after the case was settled. I don't know how you'd actually come up with a scenario where you can demonstrate reduction in permanent disability, but once you stipulate to PD, you're stuck with it unless you can demonstrate after that that there was a change or that somehow you couldn't get the video before the stipulation. So if you have any doubt in your mind as to whether or not the applicant is as disabled as they claim they are, or whether or not an AME report is accurate, try to keep discovery open and address that issue before stipulating. Obviously, you'd want to run that through a cost-benefit analysis to see whether or not it's worth it to run that kind of a risk. But if you catch wind that the applicant's disability levels are not accurate and you want to be able to demonstrate that, do it before you stipulate. Because after the stipulation, even if the AME says that the applicant wasn't as disabled as they thought they were, it's going to be a real hard thing to demonstrate and to use to reduce the permanent disability. So you're pretty much stuck with it. Now, this is an interesting decision. The Maria Padilla versus WCAB decision has to do with a vocational expert. Many times, applicant attorneys try to use a vocational expert to state that the applicant is unable to compete in the open labor market and bypass any smaller ratings by AMEs, PQMEs, or independent medical examiners that are set up by the court. And what they want to do is pretty much say, look, when Voc Expert says they're 100% disabled, we don't even need to address apportionment from any other specialist. In this case, Maria Padilla filed a claim for the back, left shoulder, urinary system, gastrointestinal system, and psych for a specific 2000 injury and a cumulative trauma for the period 2000 through 2013. And there were AMEs in ortho, internal, and urology. And if you read the case, you can see they're all the AMEs that are very commonly used in Southern California, and an independent medical examiner in psychiatry who the judge had ordered all found industrial injury, but that there was some apportionment to non-industrial factors. They also found that there was apportionment between the 2 dates of injury in a Benson-style situation. But the applicant attorney got a vocational expert who found that the applicant was 100% disabled since she couldn't compete in the open labor market. The expert's report was problematic, however, because the expert did not even bother to address the apportionment factors that the AMEs and the IME had found. And so the expert pretty much independently came up with a report saying that the applicant couldn't participate in the open labor market. If you read a lot of these rehab reports, sometimes they come up with 100% very easily without a lot of evidence. I had a case a couple of years ago where the Voc Expert said that the applicant was unable to perform her usual and customary work as a nurse's aide, but would have been capable of working as a boat captain if she had the training and knew English. So the Voc experts oftentimes will come up with 100% at the drop of a hat and demonstrate that almost everybody cannot participate in the open labor market, but they may provide some kind of very narrow or rare exception in order to look like they're being more balanced. But in this case, the expert didn't even bother to address the apportionment. And the workers' comp judge said, well, it's 100%, so therefore the applicant gets permanent total disability, makes the judge's job easy, right? Well, it turns out that the WCAB on appeal rescinded the judge's findings as to permanent disability and apportionment and said that the record needed further development. The WCAB found that the judge had not properly considered Benson and Escobedo, and that since the Voc expert had not considered apportionment at all, it was not substantial evidence. So this is a very good decision for us. It's unfortunately, I don't believe it's a published decision, but you can use the arguments and the reasoning to demonstrate that a 100% Voc expert report can be rebutted at the trial level. Demonstrate it's not substantial evidence that that expert did not review all the medical reports in the case. It is not the easy path to permanent total disability that applicant attorneys like to think it is. A Voc expert still needs to address medical evidence and apportionment. So this decision is something I think we can use in a lot of our cases where we have a Voc expert coming out and saying that the applicant can never get another job. Here's another decision that I found to be interesting. It's whether or not an AME can override utilization in IMR. There are some practice pointers I'll point to that you may want to consider in these types of situations, but now, of course, that IMR and UR are the law of the land, they may not apply as much. But anyway, in this case, it's an old injury. It's an applicant who was a handler and sorter for Federal Express who sustained low back, bilateral knee, bilateral feet, bilateral carpal tunnel injury in 1997. And in 2003, the case resolved via compromise and release with future medical left open. The parties stipulated that the AME Mandel will be the ultimate medical arbiter regarding the medical necessity for claimed industrial treatment. So, of course, at that time, it wasn't uncommon to see that kind of language in place. And that was before utilization review in IMR. So, in 2016, the applicant's treater says that the applicant needs a total left knee replacement and a weight loss program so she could have the surgery. Utilization review approved 6 months of a weight loss program, but then said that's enough, you can't lose any more weight, and denied the extension of the program. An applicant attorney appealed to IMR, which upheld UR. The attorney also asked Dr. Mandel what he thought, and Dr. Mandel said that the applicant needed to lose enough weight to the point where she could have the surgery, and would, of course, require a weight loss program to get to that point. In other words, cutting it off early before she could have the surgery was not reasonable according to the AME. The applicant attorney filed a DOR for an expedited hearing on the issue, and the judge said, well, the WCAB lacks jurisdiction because of utilization review in IMR. That case went up to the WCAB, And the defendant argued that the utilization review statutes overrode the 2003 stipulation to use Dr. Mandel for the decisions. And the WCAB actually disagreed, stating that the workers' compensation judge needed to consider the contract between the parties, the contractual agreement, and weigh the opinion of the agreed medical examiner so long as the AME's opinion constituted substantial evidence. That's an interesting decision because on one hand, the WCAB is saying you need to now defer to the AME because there is a decision, whether the WCAB could actually decide, or that the judge could decide whether or not the AME's opinion constituted substantial evidence. So you don't automatically go to the AME if the AME says something crazy. So it creates a very interesting scenario where you may actually see the judge having to make some type of medical determination. A contract and a settlement to use an AME to decide medical treatments can supersede utilization review, even if the contract was written years before that process was in place. And the second thing, again, is that the WCAB did not take away the jurisdiction and say that the AME automatically would prevail. So if the doctor is not reasonable, the board can still make a determination as to whether or not the AME's report is substantial evidence. I think this could theoretically create a logistical mess, since AMEs cost more to have them review these kinds of situations, and they don't respond as quickly as UR or IMR. So carriers who are in the situation need to figure out how to address primary treating physician treatment requests. One of the factors, of course, that exists in this case is that this is not a scenario that's going to arise in current case law. And so long as you have UR and IMR in place, I don't suspect that the parties are going to change and start, putting AMEs in charge of determining medical treatment. But it is a situation that may arise with some of your older cases. I like this case because it's another fairly simple case, but it felt good to read it. Frontline Medical Associates versus WCAB in the Kurt Wheeler case, writ was denied. Frontline Medical Associates filed a lien for $155,823.70. And the board found that the treatment was unauthorized, not reasonable or necessary, and improperly provided outside the defendant's valid MPN. Frontline filed the writ because what else are they going to do? And the writ was denied, and Frontline will not be paid. So advice to medical providers is, if you want to be paid in an admitted case where an MPN is in place, get authorization, provide reasonable and necessary treatment, and don't improperly provide treatment outside the MPN. I think this is the easiest case we're discussing today, and I'm going to leave it at that. This is a case involving Matthew Smith. It's Intercare Holding Insurance Company versus WCAB. And it's about what happens when an applicant refuses to answer relevant questions at a deposition. Matthew Smith was a roofer who sustained an admitted right shoulder injury in 2011 and to his back and right hip, and a cumulative trauma injury that ended in 2013. The defendant found out that the applicant was playing softball while he was on disability, and they decided to take his deposition. At deposition, the applicant refused to answer any questions about playing softball and asserted a Fifth Amendment right against self-incrimination. And secondly, that the questions about playing softball violated his right to privacy. Never mind that he's a workers' compensation applicant who is playing a game out in the open where he'd be readily observed. The defendant sought an order compelling the testimony, or in the alternative, that the right to collect further benefits be suspended and that the applicant pay restitution and that credit be taken for benefits paid. In other words, if the applicant wasn't going to play ball and give the information about what he'd been doing, the benefits would be suspended because there's some information that's missing, and it would be extremely relevant to whether or not he was as disabled as he claimed. That issue went to trial, and the applicant again refused to answer questions about whether he played softball. The judge found that the applicant could not be compelled to testify because it would affect his Fifth Amendment right to not self-incriminate, and that aside from potential testimony that he would have given, there was no evidence to terminate his benefits. In other words, he's not telling us that he's playing softball, and I'm not going to make him tell us that. And unless we know if he's playing softball, we can't suspend his benefits. So it's kind of a catch-22. That case went up on appeal to the WCAB, and the board found that the judge did not have authority to compel an applicant to self-incriminate. One commissioner dissented and found that he would have ordered the applicant to submit to another deposition, and if the applicant asserted his privilege against self-incrimination, he would have stayed the claim against until further order. In other words, either testify or don't get benefits. The defendant filed a petition for a writ of mandate asserting that the applicant should not be entitled to maintain a workers' compensation case while refusing to respond to reasonable questions, and that the WCAB judges indeed have discretion to compel responses to questions or, in the alternative, suspend benefits based on the applicant's actions. The applicant's attorney raised a technical response that the defendant had sought review of a non-final order over which the WCAB would not have jurisdiction, and therefore the writ was denied. The District Court of Appeals used its broad discretion to deny that in May. I do find this to be a troubling case because anytime you ask an applicant about their current levels of activity or their activities of daily living, the applicant could theoretically be self-incriminating or be incriminating themselves by testifying that they are incapable of doing things which you know that they are doing. And so, theoretically, you could end up with a situation where applicants will only answer questions about how the injury happened and what body parts hurt, and say nothing about their current level of activity. The downside to that, of course, is that you lose the opportunity to gain truthful testimony about the applicant's current condition. So I don't see this case as being settled. I think it's going to ultimately have to be heard by the WCAB again or the District Court of Appeals to determine what an applicant can be compelled to say and whether or not they can be compelled to testify. I suppose if you do have knowledge that a person is engaging in these activities, before publicizing it and setting up for a deposition and making them testify about it, this may be a case where it might be useful, if possible, to obtain some surveillance of the applicant. Otherwise, their own testimony would be the only evidence that you could use to suspend benefits. This is a coming and going rule case of Yukon Zhu versus Department of Social Services. It was decided by the Second District Court of Appeals on June 20, 2017. This is a case involving a home care provider who is contracted through the county to provide services at different homes. And what she would normally do was she would work at one home in the morning and then ride her bicycle to another home in the afternoon. One day between those two jobs, she actually got involved in an accident on her bicycle and was injured severely. And the defendant denied the claim, saying that she was not injured while she was performing services due to the employment. The defendant was asserting a theory that each separate job was a separate job, and that whatever happened between them was the applicant's own business. The trial judge found that her bike riding was transportation between the homes, and it was a mandatory part of her employment, and that the injury was AOE-COE. In other words, she had to go from one home to the next, and it was part of the injury. The WCAB, however, addressed this in light of the coming and going rule, and the way they addressed this was that the rule provides that an injury suffered during a local commute en route to a fixed place of business at fixed hours in the absence of special or extraordinary circumstances is not within the scope of employment or within the course of employment. So In this case, the applicant had one job that she would work in the morning at a fixed place and another job that she would work in the afternoon. And going between those two jobs was therefore not compensable because she was simply commuting. And a lot of this has to do with how the applicant was actually paid. In this case, she was paid by the jobs and not for her transportation between the two jobs. The workers' comp judge had relied on another case called Smith to argue that the bicycle was a required vehicle that qualified for an exception to the rule. The WCAB, of course, disagreed and found that the applicant's transportation between the two houses was for her own convenience and benefit, and that the coming and going rule applied. Commissioner Razzo dissented to that decision. But the case went up on appeal, and in June, the District Court of Appeals disagreed and said that the travel between the sites was a benefit to the Department of Social Services and was at the implied request of the department. They ruled that the commute was part and parcel of her job. And that decision actually, I think, is fairly reasonable since she was going between two specific jobs as part of her ordinary course of work to the benefit of the department. So coming and going rule is fairly clear in that case, but when you're going between two different jobs while at work, the coming and going rule does not apply as an exception to obtaining workers' compensation benefits. In this case, you have a Dole Bakersfield versus Isaiah Sargelis. You have a case where the applicant was supposed to be a trial witness. This is a case that I'm pointing out because it's a very procedural decision, and it has to do with what to do when you're setting a case for trial and how to form your pretrial conference statement and exhibit list. That's oftentimes the most important document that you have in the life of a case, is what issues you present and how you frame them and what exhibits and witnesses you list. In this case, you have an applicant who claimed an injury to his back, and at the MSC, in the pretrial conference statement, the applicant's attorney listed the applicant as a witness, but the defense attorney listed 3 witnesses, but not the applicant. At trial, the applicant's counsel submitted on the record rather than put his client on the stand, and defendant called the applicant to the stand, and the applicant attorney objected. So in other words, the attorney's saying, look, we're just going to submit on the record, we don't need any testimony, and the defense attorney wanted to ask the applicant some questions in front of the judge, but had not listed the applicant on the pretrial conference statement. The applicant attorney objected, and the judge actually sustained the objection and ruled for the applicant. After the findings and award, the defendant filed for reconsideration, and the WCAB denied the petition. Then the defendant appealed the decision to the District Court of Appeals, which annulled the workers' comp judge's award and remanded the case to the judge, asking the judge to reconsider the award after requiring the applicant to testify in cross-examination. That's a fancy way for the court to say that the judge was wrong and that the defendant should be able to call the applicant as a witness even if the defendant did not list the witness. The court ruled that the judge erred in refusing to allow the defendant to cross-examine the worker even though the defendant had not listed him as a witness, since the applicant's attorney had listed him as a witness. And the court noted that a party can call any witness disclosed at the MSC, and the parties to civil proceedings, analogized it to civil proceedings, have a due process right to cross-examine and confront witnesses. In a workers' compensation claim, an applicant is claiming the right to obtain benefits from the defendant, and the defendant has the right to confront and cross-examine them on the stand. But so the applicant would be able to be called as a witness in the case. So in the event that you fill out your pretrial conference statement and for some reason neglect to include the applicant, you can use this case to your benefit, or use reasoning in this case to your benefit. But as a practical matter, it's best to include the applicant as a witness in whatever case you're dealing with. This is an interesting case, and I originally wasn't going to mention the name of the medical provider, but I decided to go ahead and name her since she's listed throughout the body of the decision in Manuel Colegas versus Manuel Colegas versus Candace Inc., the SIGA case. Dr. Elena Kronstadt provided psychiatric treatment to the applicant from November 1998 to March 2000, and the case resolved via compromise and release in 2001. Fairly straightforward facts. Dr. Kronstadt's representative appeared at least one of the two lien conferences in 2001, and the case actually went to a lien trial in December of 2001. But Dr. Kronstadt's lien, for some reason, wasn't decided or resolved at that time. So the defendant closed the file and actually ultimately destroyed the file. 10 years later, Dr. Kronstadt was looking through her old billing and realized that there may be some extra money left over from 2001. So she filed the DOR, and the matter was set for a lien conference in November 2012. And since it was a lien conference, of course, it was continued to another lien conference in May of 2013, and again in December of 2013. Liens take forever to resolve, and it's a normal calendar in a lot of times. And so the matter was ultimately set for a lien trial in April 2014, and the trial was continued in August of 2014. So 10 years after the original settlement of the case and the original lien trial, the thing was set for 5 more hearings because of Dr. Kronstadt's DOR. So the defendant claimed the defense of lapses, and of course the lien claimant said, that's irrelevant. Lapses don't count in workers' compensation. I always list lapses as a defense in a lien case, particularly if there's been any kind of delay. And typically they say it's not relevant. But in this case, the trial judge actually found that the medical provider had been acting unreasonably and unreasonably delayed their prosecution of the case, and the trial judge dismissed the lien with prejudice and imposed sanctions of $2,000, which was probably not enough to cover the 5 hearings that had taken place and all the litigation that would have taken place on that lien, but at least it's something. The judge found that the lien was patently unmeritorious and that the defense of lapses applied. And of course, the lien trial, Kronstadt presented 9 exhibits and the defendant submitted 1 exhibit. Kronstadt appealed, and the board applied the Torres decision to discuss the burdens of proof of lien claimants. And I did want to go over this part with you as well, because it's kind of a primer on how lien claimants need to demonstrate certain things in order to recover. They need to demonstrate injury arising out of and in the course of employment when not previously established or admitted, medical necessity of the treatment at issue, reasonableness of fees, that the treatment was by the primary treating physician or a treater authorized by the PTP, and that the lien claimant's billings were properly documented and served on defendant. The appellate court noted that in this case, the claimant had not met its burden of establishing these points. All that the lien claimant actually presented at trial were a number of Dr. Kronstadt's reports, an itemized bill, a request for authorization, an appointment letter, proofs of service of the reports and invoices. There was nothing having to do with the referral or other information that would be required in that kind of a case. And the appellate court found that the evidence was indisputably incapable of establishing its claim, thus wasting the resources of the WCAB and squandering valuable calendar time. In other words, Dr. Kronstadt's approach to liens had been a monumental waste of time and money. And then, after saying that they would have failed to meet their burden of proof, the WCAB or the court got around to the defense of laches. It said that this defense applies to lien claims that are excessively delayed. In this case, Dr. Constat had not pursued her lien claim for over 10 years and did nothing since the December 2001 trial. The court said there was no explanation as to why the lien was not timely pursued after the matter was taken off calendar in 2001. Dr. Constat had argued that there was no evidence that this delay prejudiced the defendant, but the court noted that the defendant had destroyed its file, and given the passage of time and inactivity, this fact alone can constitute prejudice to the defendant. In other words, if you don't have your file anymore because you waited for 10 years for a lien claimant to act, and you finally destroyed the file, that constitutes prejudice against the defendant. So the dismissal and the sanctions remained. Recently, I've been seeing a lot of applicant attorneys actually trying to collect on old 5710 fees, claiming they were either underpaid or not paid at all. And these sometimes have to do with cases that may be 7, 8, 9 years old. And I believe the defense of latches may apply to those as well. Always raise the issue of latches, and if you destroy the file, if the claim says destroy the file, and you can demonstrate when that occurred, be sure to use that as evidence of prejudice. And that should be very helpful when you're dealing with some of these old liens. The statute of limitations changes have reduced a lot of the lien exposure. You don't have cases where lien claimants are coming back years later filing new liens, but if the lien claimant filed a lien years ago and now suddenly wants to deal with it, and they pay the activation fees in an effort to get WCAB jurisdiction, they still can be eliminated based on the defense of latches. And of course, you want to make sure that they meet the other requirements in order to demonstrate that they should be paid in the first place. So we come up to the case of the administration of an MSA. In this case, you had an applicant who had been represented at the time that the case settled, and he wanted to transfer the MSA trust administration from a vendor that had been set up as part of the settlement to himself. And he had 3 cases that resolved via compromise and release in 2011, with future medical provided for in an MSA through which the defendant would fund future medical treatment. It was over $500,000, so it's a huge MSA, and the defendant would be funding the administration of the MSA through an annuity type of system. So it wasn't a lump sum payment. The defendant worked it out with his vendor to pay a certain amount at a time. The applicant had agreed at the time of settlement that a vendor would administer the MSA, and they released the defendant, Carrier, which is state fund, from further liability for the administration of the MSA. Now, what happened was that the applicant was not very happy with the way that the third-party administrator was administering the MSA, because there were medications that he required that the MSA wasn't actually covering. You had, in other words, you had like what they call a donut hole unallocated expenses coming up, which were fairly significant, having to do with the applicant's current medical treatment and things that he needed that the fund would not pay for. And so he filed for a hearing, and the issues at that time were whether the vendor appropriately administered the MSA, and if so, whether the WCAB had jurisdiction to set aside the MSA and allow him to self-administer the account. So he said, you know what, I don't like the way this vendor is dealing with my future medical treatment. What I need now is for the board to give me the money so that I can administer it myself. The trial judge found that the applicant had not established that the vendor had administered the MSA inappropriately. And the applicant, of course, again argued that 2 of his expensive medications were not being paid out of the MSA, and he had not been fully aware of the terms of the MSA when it was initially prepared. He wanted to produce evidence that the MSA vendor was not acting in his best interest, including recorded cell phone conversations and some other things. The WCAB on appeal found that the judge should consider the nature of the agreement between state fund and the vendor and evaluate the applicant's contractual rights under the compromise and release. And of course, even though State Fund had resolved the case. The MSA was being funded through an annuity, and State Fund should no longer have been active in the actual administration of the MSA. State Fund was all of a sudden brought back into the question of whether or not they should be able to, whether the MSA was being handled adequately. So even though State Fund was now able to take a hands-off approach, provided that the vendor was appropriately handling the money, when that handling of the money came into question, State Fund was brought back into the discussion again. The WCAB also found that the applicant should establish his competency to manage his affairs and comply with CMS requirements for self-administration. I know one of the questions that I often have when settling an MSA case is whether the applicant is actually capable of administrating their own trust. Oftentimes you have people who may be very tempted to spend their money received through a settlement doing other things, and it's very important to include protective language in your compromise and release if there's an MSA in place, that the applicant fully understands their requirements to administrate the trust and spend that money. Sometimes I have a case with several $100,000 in an MSA just sitting there for the applicant to use, and I have no idea what happens once the case settles. But if State Fund can be brought in, if in the event that the third-party administrator is no longer properly handling the trust, or even if that comes into question, if Medicare gets interested in how an applicant is administrating the trust, I'd be curious as to how that works out as well. And I believe that in the event that you have an annuity situation or a structured settlement, this should be of great concern for the defendant in the case to make sure that there's as much indemnification as possible built into that settlement contract, so the defendant can't be brought in later on if the applicant failed to self-administrate properly. The fact that the WCAB was saying that the applicant should establish his competency, even though the case has been resolved for quite some time, means the competency issue could theoretically arise in any case. That case is not yet concluded. It's still up in the air. But it is somewhat uncharted territory because MSA issues are happening more and more, and they last the lifetime of the applicant. The money is there theoretically to provide enough funding for the applicant to receive a lifetime's worth of medical treatment. And the role of the WCAB over the lifetime of the applicant remains in question, particularly if the third-party vendor is contracted to provide services that are paid for out of an ongoing annuity program. And other questions that I thought of were like, what happens if the vendor goes out of business, the third-party administrator, or if the applicant self-administers a MSA, what happens if they lose their mental capacity to do so? And these are questions that we will likely face in the future as MSA settlements mature. So it's something worth thinking about now as we go into the next few years when it comes to settlements that can be structured out over the period of the applicant's life. So that is our presentation for today. There are a lot of cases we didn't get to today due to time constraints, and there are obviously other cases that are going to be coming up in the near future that are extremely important. I'd be happy to go over with you if you have any questions or concerns about any of these issues, or if you have cases that address these types of concerns and issues, I'd be happy to discuss them with you. It's a fun area of law to talk about these stories, and it's kind of neat to be able to look at case law, see how the board has already ruled on these cases, and apply that rationale to decisions that you currently have. If you have any questions, again, my contact information is on the screen. You can call me, you can email me. I've got my cell phone number there. Please feel free to use it. And I look forward to talking with you again in the future about some of this stuff. It's a lot of fun.